Hi there, and welcome to Apple World. From stunning allegations to extraordinary fights in court, the preliminary has had no deficiency of wild minutes. We've had one more occasion of supposed stash being acquainted with our space, and because of that and the resulting examination, one of our prisoners sadly needed to go to Grady emergency clinics. The other thing I would just welcome Chamber to talk with their clients about. I realize I've referenced this multiple times now. What is viewed as an okay way of behaving? This is the third time that we've had booty brought into this Z in here. This happened. We got this video from Core investigating the part we featured here. Do you see this right there as per court movements? Young Thug's kindred respondent, Keith Adams passed Porset to Young Thug, all the while assuming a pretense of a handshake directly before the whole court. Adams is serving a life sentence for homicide currently, just after what you see there in that video. Court records say that policing moved in to look at those who opposed him, yet when they looked through him, the reports say they found more booty, including percot weed and tobacco, all enclosed by plastic and food flavors to cover the smell. The court records proceed to say officials thought Adam gulped much more booty, so they surged him to Grady Emergency Clinic, they say. The court must be deferred until the end of the day. Cordarius Dorsey, otherwise called YSL Polo, was making some surprising hand signals in court on Friday. Young Thug's lawyer recorded a movement to cut off from Dorsey, guaranteeing his way of behaving could adversely influence Young Thug's opportunity for a fair preliminary. The movement understands that Mr. Dorsey showed an amateurish and unsuitable lead in the court. At the core of a lot of this tumult is Youthful Crash's lawyer Brian Steele, who has ended up at the center of attention for more than simply his protection strategies, should jump into probably the most stunning minutes that have occurred in such a long time in this high-profile case. Each opportunity, Mr. Copeland comes in the court or out of court, me accompanied by a DAA's office specialist. You see that this court is noticing you're not simply staying there in a cloud. You see precisely what's going on. You hear the examiner let you know we were in a room with Mr. Copeland, and he said, "Why, for what reason do I need to raise you? You ought to raise, this is insane." This resembles socialist Russia. Mr. West is having an absolutely terrible preliminary. The preliminary has been loaded up with issues and has extended for more than a year with no end. Knowledge, Steele's activities, and ensuing substance administering are the most recent turns in his high-profile case, which started with a jury choice in January 2023. The charges against John Doe, whose genuine name is Jeffrey Williams, incorporate infringement of Georgia's enemy of racketeering regulation, lady-related exercises, and different medication and firearm offenses. Perhaps of the latest advancement happening in this preliminary includes Doe's guard lawyer, Brian Steele, who has been establishing hatred of Center to spend the next 10 ends of the week in prison. This choice was made by Efton District Predominant Court Boss Adjudicator Eurogramville after Steele would not unveil how he found out about a classified gathering between the appointed authority examiners and a key observer. How did you learn about any of that? Well, I'm an upset as well. And the explanation. Well, I'm posing you an inquiry. How did you learn about it? I will pose you the inquiry. Okay, this core. Let me know how you got the data. Listen, anything you desire to do, tell me how you got the data, then we can feel free to go ahead. Will say is this. I was told, and I trust this concerns the court. It concerns me that you have restrictive data that you ought not be having that was ex parte. Why with a party? Why province of Georgia? What about the observer? What about Mr. Copeland, who apparently reported he's not affirming and he'll sit for quite a long time and afterward, evidently shocking court? Or excuse me, let me reword that this court probably said I can hold you for the rest of this preliminary. Miss Hilton apparently said the litigants as a whole, and afterward, every one of the 26 individuals is discarded on the off chance that that is valid. This is compulsion. Witness the terrorizing ex parte correspondences that we have an established right to be available for. So I comprehend that you're vexed towards me, yet I don't have the foggiest idea what I did, Mr. Steele. I actually need to know, how did you happen upon this data? Who let you know? What I need to know is the reason. Wasn't I there? Why, sir, I will censure you in the event that you don't let me know. Who the let me know? Let me know who this data. I need to be reprimanded. I'm not responding to that question. That is legal right to privacy data. I not legal right to confidentiality, except if you were in my chambers. That is the main way you might have at any point sort out. I let you know what I will allow. You 5 minutes in the event that you don't let me. Who know if you don't let me know what its identity is, I will place you in scorn on the grounds that that isn't legal right. To confidentiality lawyer work item honor, I nod. How could you get that data? Probably from my Chambers. Did someone let you know I'm not? You ought to have let me know you got 5 minutes. Well, I don't require it. I need to proceed with this is everything I was told by Mr. Copel's proclamations that he confessed to killing Donovan Thomas and didn't take my notes. He then recorded a movement to eliminate Judge Blango from the case and mentioned a malfeasance sting, worries about the judge's unprejudiced nature, and the general decency of the preliminary. The prequel thing about this is the way Steele requested that the appointed authority be put in the very cell that young thug was held in, which basically implies he got condemned to 10 end-of-week sleepovers with him. It's quite difficult to name some other legal advisors who have done something somewhat like him, and I'm almost certain youthful Doe is happy he wound up recruiting him in the first place. Steele blamed Judge Glenville for holding an ill-advised witness with the arraignment. This allegation was significant, proposing potential corrosion and witness terrorizing. Steele's refusal to uncover his wellspring of data led to his hatred charge and resulting prison sentence. The trade between the appointed authority and Steele was wild to see going in court, with numerous legitimate specialists and fans scrutinizing the lawfulness of his activity. With a reasonable predisposition, the adjudicator showed towards young thug's legitimate group. In his 3-hour opening explanation, Steele killed youthful hooligan's troublesome childhood and guarded against every one of the 36 obvious demonstrations recorded in the prosecution. He made sense of the setting of hooligans' web-based entertainment posts, verses, and other affirmed posse-related exercises, underscoring the rapper's right to imaginative articulation. Steele thoroughly tested the indictment's proof, especially zeroing in on the validity of the observers and the authenticity of online entertainment posts and tune verses being utilized as proof of crime. He contended that these components were imaginative articulations and not characteristic of criminal conduct in court. Steele made profound requests for young thug, specifying his troublesome childhood and individual difficulties. These requests were intended to humanate hooligan and present him as something other than a respondent in a high-profile criminal case. All through the preliminary investigation, which was actually overseen by huge media consideration and public examination, he offered a few expressions to the press, underscoring Jode's blamelessness and, what's more, ensuring the indictment's strategies. His media technique was essential for more extensive work to influence general assessment and support his client. Kenneth Copeland, otherwise known as Lil Woody, he is a vital observer in the Yo White C preliminary. He is a sentenced one who has been vigorously associated with the White So game. Copeland's declaration has been huge and quarrelsome in the preliminary. His proof was questionable, with the basic reactions and claims of memory issues. Stand by. Are you going to allow me to ask you a few inquiries? Okay, the way that old are you? Okay, what does developed mean? Okay, and when you said you're a grown-up, what number in years are you? I argue the F. Ken was hesitant to affirm and submitted various questions while on the substitute. In October 2021, Ken was captured in Efton District for having a stacked firearm in his vehicle. He has a crook foundation and has been accused of an assortment of drug-related protections following his capture. Copeland provided the police with data about past and impending violations. He demonstrated his readiness to assist with getting admission from young thug, which made his declaration an essential piece of the indictment's case. During the preliminary sentence declaration was set apart by an equivocal response in cases of memory issues. He was hesitant to affirm, submit questions about his state of being, and show his absence of participation in court procedures. His believability and dependability of his assertions have been addressed by the guard. Steele blamed the indictment for constraining Copeland into affirming by proposing he could stay in prison until every one of the cases in the RICO preliminary were settled. This charge was essential for a more extensive discussion encompassing the preliminary prompting cases. Subscribe Apple World for more videos.